Now turn to the next case on this morning's docket. And before I call it, I would like to acknowledge, I think we have some high school students in the gallery. Is that correct? No?
Maybe college. College.
College. I showed Jewell County High School.
No.
If you are here from the college, would you please stand? Very good. And what class is this? I hope you found all this just fascinating.
I'm sure they did.
All right. Thank you very much for coming. Our next case I will call is case number 102789, Rick Graham and Lisa Graham, appellees, v. Angela Herring as administrator for the estate of Elizabeth A. Jones, appellant.
Mr. Chief Justice, I'd like to ask for 3 minutes in rebuttal.
3 minutes is granted.
I'm Gregory C. Graffman. I'm from Kingman, and I represent the Grahams, who are the appellees, and I'd also note that Mr. Graham is also president of the gallery. May it please the court. This case comes in a rather different circumstance. It started out as a protection from stalking matter in Harper County District Court, and it was filed by my clients, the Grahams, and ultimately the defendant in that case, Elizabeth Jones, filed her own counterclaims for claims against the Grahams. As this was filed originally in June of 2006, and the mutual restraining orders were actually granted in November of 2006. At that point in time, the only thing that was remaining was the counterclaims from Ms. Jones. Time moved on, and in June of 27th of 2007, Ms. Jones died, and the suggestion of death was placed on the record in July of the same year, and nothing happened still. And the Grahams counsel at that time filed a motion to dismiss in April of 2008, and it wasn't until May of 2008 that a motion to substitute was actually filed. That motion ultimately was not actually granted until December of 2008, when various other sanctions were also imposed upon the Grahams. We got involved after that fact and filed a motion for reconsideration, and we focused on, at the time of the hearing in February of 2009, on the substitution issue under KSA 225. It is our position that the time from Ms. Jones' death until the motion to substitute was filed in April of 2008, that an unreasonable time had passed.
Would you agree with, I believe it was the Court of Appeals that found that the applicable time period to view is from the time of suggestion of death to the motion to substitute?
I would, Your Honor.
Filing.
I would. The motion was from the time from death, suggestion of death, to motion filing.
The motion filing. So the time that it took the court to set it for hearing, we're not going to ascribe that delay to the movant, the substitution movant, right?
I believe statutorily the time limit is, as we set forth, from suggestion to motion filing.
And having said that, we know that the trial judge, at least the first one, relied upon that additional time period, which was an application of an incorrect legal standard. And we have said that that's an abuse of discretion to apply the wrong standard. Why doesn't it go back, even if the judge is going to make the same decision? later, why doesn't it go back for application of the correct standard?
Well, Your Honor, I would disagree, I guess, initially from the characterization of what Judge Solomon and Judge Lyle did. Judge Solomon very clearly in his opinion brief stated that they did not file it within a reasonable time. That is clearly stated in Judge Solomon's opinion. In fact, in his opinion, like I believe it's the third paragraph of his opinion, he said that counsel really never addressed the timeliness issue at the hearing we had. On the motion for reconsideration, Judge Lyle said there was no new evidence. So if you look at what Judge Solomon actually had, it was some arguments under 225E, which somehow would grant them the ability to continue to act on Ms. Jones' behalf, which Judge Solomon correctly found was irrelevant. But Judge Solomon clearly stated in his opinion that it was not filed within a reasonable time period. Now, I understand the Court of Appeals, and it's also been raised in arguments, that Judge Solomon did make comments about what happened after the fact, and there were some pretty interesting things that happened after that motion for substitution was filed. But just because Judge Solomon found other actions unreasonable, that doesn't mean that the overall finding of unreasonableness that was required under the statute is invalid. It is true that he found that there was some unreasonable conduct, and Judge Lyle didn't disturb those findings when he considered it under reconsideration. But the base required statutory finding that the motion was not filed in a reasonable time period, the judge made it. He made that very clear. He went on beyond that, but I still submit that that does not mean that his original finding is somehow damaged or diminished simply because he considered other matters. He also, I believe, underlined it for emphasis in his opinion that it wasn't done in a reasonable manner. And he also said there's nothing to explain any delays that have occurred in this case. And I think statutorily that the courts of Kansas have found that if it's not filed within a reasonable time period, the case has to be dismissed, which is what Judge Solomon did and what Judge Lyle affirmed on the reconsideration.
But as I understand it, counsel, your opponent is arguing that although he may have made that finding, it was based on an erroneous interpretation of the statute in that he failed to consider other factors.
Well, Your Honor, I understand.
Are you getting to that?
I will, Your
All
Honor.
right.
I think Judge Solomon correctly determined and gave his reasons for that determination separate and apart from the prejudice issue. That the Johnson case that we cited to Judge Solomon, he relied upon, stated that prejudice was not a consideration. In his opinion...
Well, let's go back to Johnson.
Okay.
In Johnson, the trial court had told the daughter of the deceased plaintiff, you need to file a motion for substitution, told her who to substitute. 6 months later, that hadn't been done, and there was a dismissal, and then the argument on appeal was that regardless of reasonableness of the time delay, if there's no prejudice, you can't dismiss. In other words, the difference between establishing an unreasonable delay with prejudice, it was regardless of the unreasonableness of the delay, if there's no prejudice, you can't dismiss. And I know what the opinion says. It goes further and says the statute doesn't make that. But the real issue there was whether a condition preceding the dismissal is prejudice, rather than whether prejudice is a factor in determining reasonableness. You understand the distinction?
I'm not sure if I do, Judge.
Okay.
But what
if you have an unreasonable delay, and we all say, hey, there was no reason not to do it, and it's a long time, but there's no prejudice, can you avoid dismissal? That was the issue.
Yes.
Before Johnson.
Yes.
Here, the issue is, do you consider prejudice as a factor to determine whether it was unreasonable length of time or unreasonable delay?
Well, in the Johnson case, the court does not say that because you didn't follow my orders, I'm not going to consider prejudice. I don't believe that's what the Johnson case says. And I believe that the Johnson court made some valid points about the concept of prejudice, because in a substitution case, someone has died. There is nobody on the other side of the V, so to speak, and it stops. This is very different than anything else we have in terms of the bedrock of what we're doing here is having two parties to the case. And when that's the ultimate prejudice. When that person dies, until somebody is substituted into that position, the case stops as it did here. It stopped for 10 months. And that the party that's remaining, they are under a considerable amount of prejudice because it doesn't go, and it didn't. It stayed, and in this case, there was considerable land interests involved. And it just...
So you're arguing there was prejudice?
Well, I think in context...
But that's not the issue. The issue was, or at least the Court of Appeals said, the issue was that the trial court said, I can't consider prejudice, or I need not consider prejudice. And that goes back to the Court of Appeals did not reverse the decision. It reversed the methodology and the legal standards utilized, and it didn't comment on whether it was the right decision or not. It just said the correct legal standards weren't used, so we have to have overs on it. And so, I mean, it doesn't matter today if there was prejudice. That argument would be made upon remand, but tell us why prejudice is irrelevant to the determination of the reasonableness of delay.
Well, first thing, Judge Solomon was following what he believed to be the precedent of the state. And that's what he's supposed to do, I believe, is to follow the precedents of the appellate courts. The second is that in Judge Solomon's opinion, he didn't say that he didn't consider it. He just said he wasn't required to as the argument was made. And I think that's just in the terms of the Court of Appeals said we consider the totality of the circumstances, and I think Judge Solomon did that because based upon what he had on his plate to make the decision, he had some arguments under an irrelevant statute of 225E, and there was never really any contradiction or arguments based upon the timeliness of filing that motion. There really wasn't anything.
So
and
are you saying that because there was essentially no explanation for the delay at all, that you really wouldn't consider prejudice in the totality of the circumstances because that weighs so heavy in the
agree.
consideration? Is that really what you're saying? Is it wouldn't really matter if there were prejudice because there was no attempt to justify the delay?
When we're looking at the discretion Judge Solomon had, I think that's true because there was some allusions that some kind of prior legal opinion or something was given to the administrator, but there was nothing from the administrator. We had affidavits from just about everyone but that actual attorney who was the first attorney involved in this case. And considering what Judge had in front of him in terms of what he had to exercise his discretion and the fact that there was no reasonable explanation given, the timeliness was never really truly addressed, and he says it at the beginning of his opinion, he says it when he's making his decision at the end. I think that the prejudice argument really diminishes, especially when he says, I'm just not required to do an analysis of it. I'm not saying I'm not, but I'm just not required to, as that's what the argument was, that you have to. And he's saying, I'm not compelled to do that because I've got case law that says I don't. He says I can just consider it. He's not saying I don't consider it. He's not saying I do consider it. He wasn't abundantly clear, but never in his opinion does he say, I'm not considering it. I'm just not required to.
And what was the standard for Judge Solomon? I mean, he had to find that the delay was unreasonable.
Yes.
By statute.
Yes.
What is unreasonable? What standard was he to apply to make that determination? What test or factors or are there any constraints? Is it just whatever you might think that day? Or?
Well, I think it's shaped by what he was presented. He can't create facts that weren't given to him. I mean, we showed that there was essentially nothing on this that had occurred since the restraining orders were filed in November of 2006. And then when it's up to the parties to give the judge the factors that they believe he ought to utilize in terms of making his decision. And I think that's
But
what the judge did.
We're not talking about from '06. We're
Right.
talking from July of '07 to May of '08.
Right.
And prior to the 63 amendments, Kansas law had 1 year. And then when we amended was about the same time the feds amended the federal rule, and the federal rule's 90 days, but our legislature didn't take that. They took a reasonable time. So we don't have any bright line rules.
Right.
We don't have the benefit of a statute that says 1 year or longer if you can show. So there has to be something there. I mean, when the legislature replaced a time limit with reasonableness, there has to be some standard under which you make that determination, doesn't there?
Well, I would agree with that, Justice. I think that, but the bottom line, when the judge has to make that determination, he has to look at what's on his plate and what was presented to him. And he made it very clear that the foundational issue is reasonableness of that motion filing, and he's found that nothing was really given to him about that.
If he has to consider what's presented to him, why doesn't he have to consider prejudice if that's argued?
Why doesn't he have to? Because he was following case law. He says, I don't have to do it. He doesn't say he didn't.
Maybe I misunderstood you, but I thought you said the factors are shaped by what the parties present. And if a party presents prejudice, then does the judge need to consider it?
He relied on precedent. I mean, we cited it to him. He cited it in his opinion. And he just, we don't know what emphasis he placed on it, if any. But we do know that he made the foundational finding that it wasn't filed in a reasonable time.
Counsel,
I'm sorry, go ahead.
I'd like to ask a question, and I'll notify opposing counsel. I hope to pose the same question to him. The Court of Appeals said that a number of factors should be considered, and one of them was that whether the party to be substituted has shown that the action or defense has merit. Can you tell me why that would be a relevant consideration?
Well, I'm not sure where it came from. I'm not sure where they came up with that.
I think they were citing a New York case, McDonald versus Drazen.
I assume that they are wanting to. It doesn't really make a lot of sense to me that would be something you would want, that you would mandate. Would have to be, the way I read the opinion is that they're sending it back to Judge Solomon, and they want him just to look at all kinds of considerations.
All relevant circumstances.
All relevant circumstances. And to me, that's a Pandora's box, because we're railing on Judge Solomon because he considered some things after the motion filing. But to me, that would seem to be a circumstance too, if we're going to open up this wide-ranging box of considering everything.
Well, let me tell you, they said specific consideration should be given to, then the third factor was whether the party to be substituted has shown that the action or defense has merit. So I'm asking if you can tell us why you think that might be one of the relevant circumstances for Judge Solomon to consider on remand.
Well, if he is required to do that, it would take an analysis of actually the entire case to see if the new administrator stepping into the shoes of this woman in a stalking case has any defenses or any claim, I guess, against the Grahams in terms of reforming a contract. I mean, that contract was dissolved as a part of the sanctions in this case. That's what they're asking for. It doesn't seem to be. It seems to be going beyond what we're trying to do here in terms of. I don't know why that is so much more important than some of the other things. That's the best I can answer it, Justice.
Very good. Well, perhaps when you come up on rebuttal, you will have thought of something you wanted to add. If not, that's fine.
Okay.
Thank you, counsel. Any further questions? Thank you, counsel.
May it please the court, Steve Kerwick of Wichita here for the original appellant. Angela Herring is administrator for the Elizabeth Jones estate. Ms. Herring is with us here in the courtroom today.
What did you present to Judge Solomon in the way of support of the motion?
I'm glad you asked that, Your Honor. You picked me up for something later on down my outline. If you look in Volume 6 of the Record on Appeal, there's some transcript. Ms. Herring testified to some extent as to what happened. It's not a lot because a lot of interruptions and objections by counsel, but basically it goes to this. This is a case that comes up, and on Chief Justice's question, just to tie it back for a moment, this is going to go to the merits. The merits and defense or lack of defense by this point had nothing to do with the original all stalking. That case, I think, has abated and has no relevance here. It's all going to go to the question where Mrs. Jones was trying to rescind her contract to turn the land over to Mr. Graham. And the exchange of considerations for taking care of the cattle and whatnot.
But it seems like if the merits can trump an unreasonable delay, then you've sort of swallowed the rule, haven't you?
Well, I don't know that they trump it, Your Honor, but the merits are something that has to be considered, and I'm flip-flopping questions now.
I could see where an obviously frivolous claim could play into the determination of whether the delay was unreasonable, but it seems that you can't allow a meritorious claim to override what is an obviously unreasonable delay. Would you agree with that?
Yes, but I don't think that's the issue we get back to. I think what that New York I think it was a trial court in New York was trying to say, maybe the appellate division, was that when you look at this is kind of like the way you analyze a default. The courts are here to try and administer justice within the range of the law as well as you can, and when a default has been taken to get a recovery that isn't well supported on the merits, or to kick a meritorious case out is I think, a crucial consideration to make in determining whether to set aside a default or not. We're trying to give people their day in court on the merits of things, and that's what I think they're saying in New York. Is this just something to buy some more time for more delay? Is it dilatory? Is it frivolous or whatever else? Or is this something where the delay is being used to cloak what's going to be an injustice, namely that the Jones estate has lost its day in court for an opportunity to come in and say, yes, we were treated badly by Mr. Graham, and this should have been set aside, and this should go back to the estate and should go back to the devicee under the estate, who's Mrs. Herring, which, of course, is what's going to happen if the original Judge Solomon rule is affirmed, if the Court of Appeals is set aside. This case is poof, gone and out, and Mr. Graham has got all the real estate, regardless of whatever all the merits of that particular underlying question. And in a case as strange and as unusual as this one is, emanating out of the restraint from stalking, it's not too difficult to lose sight of that fact. But that's really what we're all here for before. And
does Volume 6 explain to us there was an attorney for Ms. Jones.
Right.
After her death, then an estate wasn't filed right away, and then there was another attorney that came in and got the administrator appointed. And is there an explanation of what happened and why one attorney didn't carry through? Or
there's some of that in there, Your Honor. Probably it could have been done up a little better. Let me try and go back what I think the overall facts are, because these really weren't heavily in dispute. A lot of these lawyers are in the courtroom, and some of them have submitted affidavits. Judge Solomon was not impressed by that. I don't dispute that he didn't think that was much of an argument, but I disagree strongly that this was just kind of an empty card where they gave him nothing to work with. I think, again, to what you've got here, Mrs. Jones, who is dying of end-stage renal cancer, hires Attorney Williams, who's with some kind of a disability firm up here in Topeka. Long way, and just Johnson, I suppose you above all understand the difficulties of state line practice, because Miss Herring lives down in Enid, Oklahoma, and the attorney representing Mrs. Jones was not one of her selection. Her aunt dies now, and all of a sudden that's a shock, and things get shaken up. Apparently, Mr. Williams did not practice what he might describe as Martindale-Hubbell AV kind of analysis of this problem over whether the claims for rescission and setting aside the contract, whether they abated or not, what were claims arising out of contract and equity on one hand, and on the other hand, the protection from stalking, which I don't know if they abated, but I can't imagine to set a question of law like that would not abate with the death of Mrs. Jones. Time goes on. Williams is trying to figure it out. He doesn't get it well. I think, like many lawyers, he probably sits on it too long. He's got a client he hasn't dealt with before down in Enid, Oklahoma, and the time runs on. Whether that's excusable neglect or not is another issue for another day, but it's one that deserves to be considered and evaluated by the court rather than just sloughed off as something that is per se unreasonable in terms of the delay. And I think the best you can say is when the motion to dismiss is filed in the early part of April 2008, Ms. Herring then realizes there's some kind of problem here with the attorney she's got. She consults some other counsel and gets Alan Gehring from Medicine Lodge, who immediately jumps on it, immediately sets up the estate, has it filed in about 2.5 weeks' time, and files the motion for substitution. And that's where I want to go back, Mr. Chief Justice. I'm trying to think if I've got your question analyzed. I hope I answered to your satisfaction of what this question of the merits and non-merits is. I think that language is out there designed to require, if you're going to give the remedy of allowing this substitution and not consider it unreasonable, it ought to be based on where's the beef. Is there something in there after we go back to the merits, and this is not something that's a mere sham to drag on a little bit more or perhaps be settlement fodder. At this point, I think the easy way to decide this, and I may be explaining things that the court already understands. I'm sorry.
I'd like to backtrack just a little bit, counsel. I know you've responded to my question. I want to burrow down just a little deeper. The statute says if the motion is not made within a reasonable time.
Right.
So my question is, how does the merit of the defense or the claim enter into whether it was a reasonable time? Why is that consideration at all?
I think
I
again,
can
it
see
goes-
where someone would come in and say, I did not get the notice, or the dog ate my notice, or something like that. But I'm just having a little bit of difficulty seeing whether the merits of the claim would enter into that calculus.
I think it goes to the goals the Civil Procedure Code set up in 6101 or 6201, or one of them designed to, can't recite them all by heart, but I think you're trying to get the speedy, just, reasonable disposition of claims. The Civil Procedure Code isn't out there to provide kind of a trick book of procedural ways to get by where rules and time limits and things are designed to throw people out simply for the purpose of speeding things along in the courts. But God knows the courts do need to move as reasonably as they can, and so there needs to be some balancing of considerations. When you're on a close balance and things, one question goes, if you're going to allow this, if you're going to work in the gray areas of what's reasonable or not for allowing a little extra time, whether or not that decision to be resolved, to be evaluated a little bit later on is something meaty and important and critical, that's right there for reasonableness. If you get down that somebody has simply brought an abusive case or, as I said, a frivolous one, or is just trying to drag it out some more to get some settlement leverage or some other advantage like that, and there's not going to be a reasonable position on the other side like that, then I think the idea of allowing somebody leniency and extra time in which to substitute or to consider it reasonable, then I think that's a critical consideration in taking kind of a harsher standpoint. And this goes where I wanted to go next, there's.
Before you get off that, counsel, can I ask about burden of proof? Because it's been bugging me a little bit in looking at this. If prejudice is an element that needs to be considered by the court, do you have the burden to show a lack of prejudice because you're the moving party wanting to substitute and show that you're doing it within a reasonable time, or does the other guy the opposing party have the burden of proof to show that they are prejudiced?
Well, it seems to me to be trying to show some point in the affirmative as kind of a debating standard. The burden would be on the party resisting to show prejudice, and not just prejudice, but unfair prejudice. Obviously, there's something involved whenever there's a delay going through a little bit, but the idea is you don't want unfair prejudice. How, in fact, is Mr. Graham worse off now than if this matter had first been evaluated in spring and early summer of 2008? I don't think he has at all. He's held the land in the meantime. It's not seriously a question of prejudice. I don't know of any showing that witness evaluations and whatnot are going to be witness investigation is going to be harmed by this any more than otherwise. If anything, the party more prejudiced is going to be the Jones-Herring case, because Mrs. Jones is dead now and did not have much in the way of testimony to go ahead and support the claim coming out of her mouth. And that's a big burden we're going to have to face further on down the line, but we would like at least the opportunity to be able to do so.
Which, as I understand it, you would not have to show absolutely no prejudice to the opposing party. It's okay if you showed a little bit of prejudice because your claim is so much more meritorious than the average claim, and that overrides what little prejudice there may have been. You also have to explain, as I understand it, what diligence you used. And as I understand it, you're prepared to put on that evidence. Correct?
Yes, Your Honor.
Okay, so this is just kind of a big mixture for Judge Solomon to look at.
And like any multifaceted kind of case, there's it's very difficult to try and find one component of that's going to be telling in and of itself. As far as the merit of the case overall, obviously this can't go so far that the ruling on whether or not the delay was reasonable or not reasonable is just going to subsume the whole opinion on the merits. But just the question, is this something we do have, in fact, a verified petition, which is something with evidentiary value, as recognized by Judge Solomon in the first hearing for substitution in December of 2008, where Mrs. Jones
when he gave
online
default
said
judgment. He gave default judgment on the verified petition.
that was all that was up before him then, but at least it was not a purely unverified petition. It was something that had some evidentiary value about it as sworn testimony, that there was something there, that this lady felt she had been done wrong in terms of conveying over her property, which may well be very meaningful property now given the slant drilling issues that are taking place out in Harper County in a way that may not have been evident back in 2006 when some of this was kicking off. I don't know that for a fact. I'm just putting that out, that this is not simply a case of grudges and personal animosity.
Just so I'm clear, if we had not reviewed this case and we just said the Court of Appeals opinion stands, they reversed and remanded to Judge Solomon and said, here are some of the specific factors you need to consider. Let's assume he dutifully followed their mandate, and then he said this is not filed within a reasonable time. What would the standard of review of that decision be on appeal?
It'd still be abuse of discretion, but I think it would be the other version of abuse of discretion, not the incorrect legal standard if it's done as you say, but it would be the abuse of discretion. Is this something that no reasonable person would adopt? Same name, different tests.
All right, thank you.
From what you're saying, I take it you read the Court of Appeals opinion as not being an exclusive list of factors that a trial judge has to use as a checklist.
That's correct, Your Honor, and you just can't throw this off. If reasonableness does not include prejudice, what does it include? And I think New York court's trying to put out some things that ought to be looked at in this big tapestry called reasonableness. And one of them is this just something that we wish had gone through sooner. And let me stop here. One reason, if you're going to the time after the motion's filed, which Justice Johnson, I know they're not supposed to do, and we've argued continually they shouldn't do. But if you're looking at the time afterwards, there is a lot of in pari delicto. I mean, both sides caused the delay between May of 2008 and December 2008, not the least of which was the Grahams with their recalcitrance and resistance to discovery, which is what sets this up for the default judgment going through. Now, really, that should not be an issue, but I just want to put down that this is not simply a question of Attorney Williams from Topeka, Kansas, and Ms. Herring dragging this thing out or not understanding what's going on and causing all of the delay, which so irritated Judge Solomon.
If it's not a checklist, then what did Judge Solomon do wrong in saying that I don't have to consider prejudice?
Well, he ruled out something he should have.
Why? Why do we have? I thought, as I understood you to say, that we're not doing this as a checklist of things that the judge has to tick off as he makes he or she makes that consideration.
I maybe overstated it then. What I was trying to say is it's a sort of a tapestry or collection of items, some of which are going to balance others, and there's no precise mathematical way to go ahead and put those together. It's going to vary from case to case.
Isn't the culprit
It's an
here?
Go ahead. I'm sorry. I was just going to say my reading of the Court of Appeals was that here is a list of factors that should be considered, almost mandatory. But if you want to consider other things, you're welcome to. Do you agree or disagree with that? Maybe that
That's
helps.
correct to me, Your Honor.
You're
It's
agreeing
going to
with
vary from case to case whether there are elements to go ahead and consider there or not. You may have cases with no prejudice. I think here there was not any significant prejudice to the Grahams. I don't know what it would be. Again, if it's significant unfair prejudice other than anything that accompanies a delay of 6 or 7 months in any case. And I mention that almost facetiously because we're now 3 months, almost 3 years since the first appeal was argued in the Court of Appeals, so it shrinks to insignificance there. But
The culprit here, not that whether he did or didn't consider the prejudice, it's that he misconstrued whether he could consider prejudice. I mean, if a judge makes a determination and believes that prejudice is not a factor that can be used, then that at least puts us in an area of uncertainty of what the judge would have done if the judge would have believed that he or she could consider.
that's certainly a neater and cleaner way to approach it, Your Honor. And if I failed and strayed from that too much, I apologize. I think if you don't consider prejudice, then what does reasonableness mean? And why do we not simply have the federal court's 90-day standard?
The flip side of that is if it's obviously an unreasonable delay, that there's no explanation at all for waiting 10 years, but there's no prejudice that could be shown, that doesn't give you a win card based solely on prejudice if everything else is obviously unreasonable, does it? Prejudice can't trump other egregious conduct or delay.
Well, maybe there you're in the case of Johnson versus Farm Bureau or whatever it was, where the unreasonableness, in fact, is a party that thumbed their nose back at the court and failed to do things within 60 days as they were required to. I don't know we have such egregious conduct. We have a significant delay of which we are not proud by any means. But I think we also have a situation where there was no particularly meaningful prejudice there. Prejudice is still a subset or a component of the overall question of reasonableness or not. And again, I think probably the tiebreaker comes that if everything pretty well balances out, the procedure system and our general philosophy of civil procedure would suggest a case ought to be decided on its merits rather than tossed on a procedural requirement in terms of a specific number of days or months the way the feds do. Again, if that's what we wanted, that's probably what our legislature would have enacted, to have two results that are obviously so philosophically different. If the case obviously stunk so badly on the merits that something turned up in the document where Mrs. Jones conceded a major flaw in the case, not present here, but if that was there, then perhaps that would show less reason to go ahead and be tolerant of the timing for the motion to substitute and a greater prejudice to Mr. Graham. But again, that's not true here. I don't think there's a particularly significant showing of unfair prejudice in any sort of situation. And I think there is some explanation in terms of the counsel relationship and the residence of now Mrs. Herring and the question of the attorney's conduct in there, that the tiebreaker in an evenly balanced case ought to fall towards a reasonable time for the substitution motion, and therefore to allow the case to be decided on the merits.
Did you have any further questions, Justice Lukert?
Well, do you disagree with your counsel's reading of or understanding of Judge Solomon's decision when counsel argued that Judge Solomon never went so far as to say he could not consider prejudice, just that he was not considering prejudice? Was not required.
I think that's right, Justice Lukert, but I'd have to go back and look exactly what was said on the record and what's in any of the briefing on that. I do believe those are recorded. I'm a little hesitant to go off without taking a minute and trying to find where that was. The record will speak for itself.
Any further questions of counsel? Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
Thank you, Your Honor. Your Honor, I'd like to get to your question. I've had some consideration of that in terms of what the Court of Appeals actually said, and it seems to me that my first response is, in all this line of cases for 225, that kind of analysis has not shown up in any of them, where you have to determine, make some kind of calculation in terms of whether there's a meritorious defense. To me, that's rewriting something into the case law that I have not seen. My research is not, and none of the cases we cite require that kind of initial calculation. It's almost like the Court of Appeals is requesting that the judge basically look at the merits and have a quasi mini trial, either in the court or in their mind or in their calculation term, whether or not this person can be substituted. The statute doesn't require that on its face. It's just a reasonable time, and it's in the syllabus of their case. So I mean that they are listing things, and I think that would set some parameters that judges down the line are going to think, well, I better follow these three things, or we're going to be repealed or reversed. And I don't think that's appropriate. Because it steps outside the lines of what we've got for precedent, and there are plenty of cases on 225 itself, without having to go anywhere else, about reasonable time. And based upon what two different district judges had in front of them, they both found that there was not a reasonable time between the death and the filing of that motion.
Would you agree that we need, or that it's reasonable for us to look at the letter of opinion of Judge Solomon to determine what his ruling was?
It's part of the record, Your Honor. I absolutely...
And when he says, quote, accordingly, this court is not required to use a prejudice analysis in determining the issues herein, unquote, would you say that I'm misconstruing that to say that the judge thought, and that's after he had spent 3 paragraphs talking about Johnson versus Farm Bureau, that he thought that he was not required to do that?
I think, based upon the argument we made, based upon the Johnson case we cited, I think he is saying that I don't have to. Not that I didn't, but I don't have to. Because that's the problem, is the other side has tried to make this the bright line issue. We got to show prejudice, or we can't do anything. We have no argument if we have no prejudice. And we're saying, look at what he had on his plate in front of him.
Let me ask you, take you to a different place, where he underlines that there was a time period of 17 months from the date of the suggestion of death to the date the formal substitution motion was actually effectuated.
Yes.
What does that mean? If he puts it in there and emphasizes it, does that mean that didn't factor into the calculus?
Well, Your Honor, he was referring the effectuation language comes from the Long case, and the Long case was holding that it was the Court of Appeals. It was at oral arguments at the Court of Appeals, and sua sponte, they said that you haven't substituted, and it's been 7 months since the person deceased, and you have not effectuated the substitution in that time period. Judge Solomon, earlier in the opinion, quoted that part
right above that. He said 7 months. The Court of Appeals said 7 months was unreasonable. Here we have 17 months. And he's comparing 7 to 17, but the 17 was on a time frame that's not permitted by the statute. And how can we be certain that he hasn't applied the wrong legal standard when that's set right there?
In other parts of that opinion, though, Justice, he clearly says that the filing deadline was unreasonable. He says there's about 3 different spots in the opinion where he touches upon that, and he very clearly says something along the lines of the first 7 months or the 10 months is unreasonable, and then the time beyond that is also unreasonable. But as I said previously, just because the judge felt that there was other time problems that were unreasonable, and we submit there was some very unreasonable conduct, that doesn't make his statutory finding infirmed.
And what he says, while the numerous arguments have been put forth to explain the delays, the hearing record of the February 17, 2009 hearing reveals no reasonable explanation for any of the delays, especially the 7-month delay between the filing of the motion to substitute and the effectuation thereof, end quote.
The judge clearly wasn't happy that it took so long to get somebody substituted in, but he did do what the statute required. He did take the evidence, and he commented on the evidence in front of him. Judge Lyle commented on the lack of new evidence in front of him in terms of what was on the judge's table when he was trying to make this determination. And Judge Solomon was clear that there was no real discussion, no real excuse, no real evidence in terms of the timeliness of filing that motion. There really wasn't. And now to come in and try to trump with prejudice, or now what the Court of Appeals is doing, here's all these 3 things that weren't in the case law, it just seems a little oppressive to me. Because this is stepping outside of what we've worked with in terms of the statute.
Even though the statutory period is substitution, notice of substitution, or notice of death to the motion for substitution, don't you think that prior time period from death to the substitution can be a factor in considering how reasonable the period was that it took for a response?
Well, that's the problem I have with this, is because we're bashing Judge Solomon for looking at those things. But if you read the Court of Appeals opinion, it says here's these three things and other things. We're not limited. You can talk about other things. And I think you're right. I think that the time period after the motion was filed could suddenly now become a factor in terms of determining this. But on one hand, we're criticizing Judge Solomon for looking at those things and being unhappy about it, while he still made the statutory required finding. But it seems to me that now that can suddenly be fair game.
Any further questions of counsel?
I do want to ask a question about the burden of proof on prejudice. Do you agree that you had it?
I think we had a lot of prejudice, Justice.
No, well, that you had the burden to demonstrate prejudice as opposed to the moving party having to show a lack of prejudice.
Well,
in justifying the reasonableness of the time.
It seems to be that's where it's fallen, is on us, and I think we could, and I still think the foundational prejudice is not having an opponent. And I think that cuts to the core, because the case law says without another party, everything's a nullity from that point beyond, and lots of things happen from that point beyond in this case. And so that's why I don't get so wrapped up on the prejudice determinations, because I think we had it, and I think it's foundational prejudice because we didn't have an opponent. for a long time, and it was beyond the reasonable time allowed by the statute.
Any further questions? Thank you, counsel.
Thank you, Your Honors.
Thank you both for your arguments this morning. The court will take this matter under advisement. This time the court is in recess for 15 minutes.